Hi everyone, I'm pleased to begin our presentation on the legal implication of cyberbullying in Malaysia. Today, I will start our presentation by introducing the introduction and problem statement for our research on cyberbullying in Malaysia. So now let's begin with the introduction. As all we know, the internet has become an essential part of our daily life. According to World Bank, the internet is widely used worldwide with 4.66 billion active internet users globally, which is 60% of the world's population, and the largest number of online users originating from Asia, including Malaysia. According to MCMC Internet User Survey, the percentage of Internet users increased from 76.9% in 2016 to 87.4% in 2018. Around 24.6 million Malaysia actively use social networking platforms such as Facebook, which being the most frequently used, followed by Instagram and YouTube. However, alongside this growth come negative effect, and cyberbullying being one of the most concerning. UNICEF defines cyberbullying as bullying with the usage of digital technologies that can take place on social media, gaming platforms, and mobile phones. In Malaysia, cyberbullying among youth is rising, with a recent study shows that 52% of Malaysian adolescents have experienced cyberbullying. In addition, in 2020, Malaysia ranked second in Asia among 28 countries for youth cyberbullying cases. This is conducted by a global survey. This shows that how serious this problem has become. Next, I would like to present about problem statement for our research. According to MCMC, many complaints were received involving cyberbullying from 2016 to 2020. In 2017 alone, over 80% of Malaysian internet users reported experiencing harassment, especially young people. And the consequences of cyberbullying have been heartbreaking. There have been several tragic cases happen during this year. In 2019, a teenage girl in Sarawak died by suicide after posting an Instagram poll asking her followers whether she should live or die. Unfortunately, the majority voted for her to die. In 2020, a 20 years old teenager committed suicide by hanging herself in home after receiving negative comment on her TikTok videos that had been go viral on Facebook. Now we will look at the research question for our study. This research is guided by three important questions. First, to what extent are current Malaysian law effective in addressing and preventing cyberbullying? Second, what are legal gaps or challenges in enforcing anti-cyberbullying laws in Malaysia? And third, how can these laws be improved through legal reform and comparative legislative insights? This question help direct our focus on evaluating existing laws and identifying areas for improvement in Malaysia's legal response to cyberbullying. Now we will look at the research objective for our studies. The main objective of this study are: first, to analyze to what extent are current Malaysian law effective in addressing and preventing cyberbullying. Secondly, to identify the legal gaps or challenges in enforcing anti-cyberbullying laws in Malaysia. And thirdly, to propose legal reforms for improving Malaysia's cyberbullying laws by analyzing comparative legislation from selected jurisdictions. Now, moving to the scope of study for our research. This research specifically focuses on the legal provision regarding cyberbullying in Malaysia. We aim to analyze the effectiveness of existing law that currently apply to handle cyberbullying, since Malaysia does not yet have a specific law dedicated to this issue. The main legal provision that we will examine include the Communication and Multimedia Act 1998, the Computer Crime Act 1997, the Penal Code, the Evidence Act 1915, and the Personal Data Protection Amendment Act 2024. Besides evaluating this law, our research also aims to identify legal enforcement challenges such as the anonymity of perpetrators, limited enforcement power, and the absence of clear legal definition for cyberbullying. To strengthen our analysis, we will conduct a comparative study with countries like the United Kingdom, Japan, and the Philippines, all which have implemented specific legislation to tackle with cyberbullying more directly. Some examples include the Protection from Harassment Act 1997 from the UK and the Anti-Bullying Act 2013 from the Philippines. By comparing Malaysian law with these international models, our research hopes to evaluate the adequacy of our current legal framework and propose practical legal reforms to improve how cyberbullying is addressed in Malaysia.
So we move on to the next, which is research method. Our group used the doctrinal legal research method, which means we focus on analyzing laws, court cases, and legal articles to understand how cyberbullying is handled under Malaysian law. This method fits our research because we wanted to examine how effective current laws are, like the Communications and Multimedia Act, the Penal Code, and how judges interpret them in cyberbullying cases. We use only secondary sources such as legal databases like CLJ Law and LexisNexis to get statutes and case law. We also refer to the articles from Google Scholar, UNICEF Malaysia, and MCMC reports for data and expert opinions. We follow a purposely sampling method, meaning we carefully selected only the laws, cases, and articles that were directly related to cyberbullying. This helped us stay focused and go deeper into the topic. This method is suitable because it allowed us to identify weaknesses in the law, like the lack of enforcement, vague definitions, and low awareness. By comparing Malaysia's situation with other countries like the UK, we were able to suggest improvement to make our law stronger and clearer.
Alright, now I would like to share some limitations that we faced during our study and the possible solutions in order to improve it in the future. The first one is limited access to victims of cyberbullying. A lot of victims may feel uncomfortable to share their own personal and emotional experiences, which affects data collections. So, in order to address this, the future research must ensure the anonymity and confidentiality regarding the victims to create a safer place for them. The second one is absence of legal framework in Malaysia. Currently, the victims only rely on general provisions under the Communication and Multimedia Act 1998 and the Penal Code, which limits the depth of legal analysis. Therefore, the development of the dedicated cyberbullying law is needed from a stronger model, like a Singapore Protection from Harassment Act, or recognized as POHA, and the UK's Online Safety Act 2023. Last but not least is time constraints in conducting research. So, it is challenging for us to conduct this research in a large-scale observation regarding the cyberbullying effects, as it is being conducted within a limited time frame. So, to manage this, the study need to focus more on a smaller group of individuals which is the most affected by the cyberbullying. Additionally, secondary sources such as MCMC reports also play an important role that can be used to support the research findings. There are a lot of significance of these studies, which is the first one is raise public awareness and shows to the public how seriousness of this issue. The second one, highlight the need for an urgent action from the authority, and encourage social responsibility. Next, this research also identified legal gaps in our country and proposed for a better laws such as UK's laws and Singapore laws. We also propose legal and non-legal solutions in order to address this problem effectively. Last but not least, this research also aims to empower victims and create a safer place for them.
Okay, I will explain about the literature review. Cyberbullying is a growing social problem in Malaysia, driven by the widespread use of social media, especially among youth. Why among youth? Because most of young people like to doom scrolling on their social media. The main platform are Instagram, Twitter, and other platforms. The data show a 55.6% rise in cases, with over 62% of teens experiencing cyberbullying. The data also highlight the urgent need for awareness, prevention, and support to protect young people's mental health. Next, I will explain about laws for cyberbullying in Malaysia. Although Malaysia does not have the specific laws about cyberbullying, but it often relies on the existing law. The first is Communication and Multimedia Act 1998 under Section 233, which criminalized sending obscene, indecent, false threatening, or abusive content online with intent to harass or intimidate. The penalty is up to 50,000 fine or 1 year imprisonment or both, and also 1,000 daily fine for ongoing offence. Second, Computer Crimes Act 1997. It was state under Section 3 punishes unauthorized computer access, which are hacking, the fine up to 50,000 or 5 years imprisonment or both. Under Section 4, it states about the punishes unauthorized access with intent to commit fraud or harm. Under Section 5, punish unauthorized data alteration, which the punish are fined up to 100,000 or 10 years imprisonment or both. Third, Evidence Act 1950 under Section 114A, presume a person is responsible for content published under their name or with their help unless proven otherwise. It also helps identify anonymous cyberbullies. Fourth, the Penal Code under Section 499 about defamation, Section 103 criminal harassment, Section 500, 506 criminal intimidation, Section 509 insult with intent to provoke. So all of these Penal Code section of Penal Code, traditional provision applied to online cases, though enforcement is harder for anonymous or digital evidence. Fifth, the last is the Personal Data Protection Amendment Act 2024, which strengthens protection of personal data like photos, identity, or information. Second, requires proper data handling, security, and breach reporting. Fourth, empowers individuals to request corrections or deletion of their data. And last, aims to prevent misuse of personal data in cyberbullying. So, the laws for cyberbullying in Malaysia, the existing laws for cyberbullying have five. Because Malaysia does not have the specific laws about cyberbullying, so it have the gaps in Malaysian cyberbullying laws because it often relies on the existing laws. So I will touch about the assessing the gaps in Malaysian cyberbullying laws. According to Nurul Huda and Nazli in one of the article, state that Malaysia's current legal framework does not specifically address cyberbullying. The existing laws like the Penal Code, and the Communication Multimedia Act and others laws that I've mentioned before in previous slides are too general with no clear provision targeting online harassment. Section 233 of the CMA covers offensive online content but does not directly criminalize cyberbullying. Agencies like Cybersecurity Malaysia, MCMC, and the police respond to cases, but laws are reactive rather than preventive. There is a strong call for dedicated legislation similar to UK's. UK's have the specific laws about cyberbullying. So, Malaysia is encouraged to do the same, like other countries, like Japan, UK, Philippines, and the US. Based on my research, it shows that United Kingdom has the specific laws for cyberbullying. The first is Education and Inspection Act 2006, which allows teachers to manage student behavior outside school, for example, confiscate their phones that used for cyberbullying. Second, Protection from Harassment Act 1997 prohibits repeated behavior that causing distress or fear and also provide civil and criminal remedies like imprisonment or fines. Third, Communication Act 2003, Section 127, criminalize sending threatening, offensive, or misleading message through electronic communication, like through their gadget, maybe phone, laptop, and others. Telecommunication Act 1988 Section 43 addresses abuse of public telecommunication system to cause injury or distress, and Public Order Act 1986, which covers threatening or abusive behavior including online action that causing harassment or alarm. Last but not least, Obscene Publication Act 1959 criminalized distribution of material intended to deprove or corrupt with penalties of fines or imprisonment. Moreover, the laws about Computer Misuse Act 1990, which criminalized unauthorized access to computer system. These laws relevant for hacking that related to cyberbullying. Crime and Disorder Act 1998 relevant for addressing behavior that causing alarm or distress. And lastly, the Defamation Act 2013 protects against malicious online comments that damage people's reputation. So all of this is the laws for cyberbullying in United Kingdom. To conclude, cyberbullying poses a serious threat in today's digital age, especially among younger generation, with a 52% prevalence rate among Malaysian adolescents, and Malaysia ranks second in Asia for youth cyberbullying in 2020. This study using doctrinal legal analysis reviewed laws such as the Communication and Multimedia Act, the Computer Crimes Act, and the Penal Code. While these laws provide same protection, their general nature makes them difficult to apply effectively to the specific and evolving nature of cyberbullying. Because of this existing laws, I made a research about the assessing the gaps of the cyberbullying of the Malaysian law. Limitation like time constraint and the lack of a specific statute were addressed through focused legal discussion and comparison with the UK legislation. The study emphasized the urgent need for Malaysia to enact clear, specific laws that target cyberbullying. So means that Malaysia need to have the specific laws about the cyberbullying. Unlike the UK, which has direct legislation, Malaysia Malaysia often relies on general laws. They are often hard to enforce online. Moving forward, legal reform combined with public education, awareness, and stronger enforcement, which is essential to protect victims and deter offenders, ensuring a safer digital environment for all.